Hi. In the previous video, I have briefed you about the circumstances which has led to the creation of the new law called Insolvency and Bankruptcy Code. So, learning from the previous experiences or past failures under the various legislations, the government had introduced a new law, which is a code with an intention to efficient handling of the conflicts between debtor and creditor or stakeholders, and to avoid any kind of destruction in the value of the assets, to put in a mechanism for identification of the reasons for the failure of the business, whether it is financial, business failure, or a fraudulent reasons. And it is also envisaged to ensure that it is not the divine right of a promoter to continue in the business of the company or control of the company if he is unable to pay the debts to the banks or other persons. And it is also envisaged to avoid illegitimate transfer of wealth by the promoters to their closed relations or to their own personal accounts. So, unlike other Indian laws, this particular law had catched up in a fast evolving manner, and many of the conflicting decisions were passed by the benches, by the judicial forums in the early stages. And whenever there was a conflict between the judiciary and as well as the legislature had actually acted very proactively by making the amendments to suit the requirements of the judiciary. And the government as well as the regulator created by the IBC is called Insolvency and Bankruptcy Board of India, had acted in a very proactive manner. And I would like to state that it is one of the kind of the best legislations in the Indian history due to these 2-3 factors. One is proactiveness. Second one is the fast evolving the type of the law, etc. So if you see a legislation, it is better to understand the preamble of the code to see the intention of the legislature while creating this law. The intention is like one is to consolidate and amend the insolvency laws in India. There are multiple legislations I had mentioned before that has to be consolidated. That is one of the objective of this act, which preamble states. Next is to maximize the value of the assets of the particular company, which is called a corporate debtor or a corporate person. And we know that when a company is facing insolvency, they will go into a deep trouble without any help from any side. And that will actually resulting in a reduction in their value and their saleability. But the Insolvency and Bankruptcy Code is meant to protect and maximize the value of those assets. And it is also to promote entrepreneurship, availability of the credit. We know that the money which is given by the bank is a public money. If the banks are unable to recover that from the debtors, it is going to be, the nation is going to face certain issues. So that when you are putting a law which is enabling the banks to recover the money as fast as possible, that is actually an adding to the nation's wealth. And it is also intended to balance the interest of stakeholders. Stakeholders means there are different stakeholders for a company, whether employees, it can be operational creditors such as suppliers of the goods or service providers, financial creditors such as banks, then comes the promoters, then comes the other unsecured creditors. There are multiple government dues, statutory dues, many are there. So, in balancing the interest of all these stakeholders is one of the major objective of this particular legislation. If you see SURFACI is basically meant to protect the interest of the financial creditor alone. And there is other creditors' interests are not at all considered in this particular law. That is one of the lacuna under those legislation. But this particular legislation wants to address that particular pressing issues. And another objective of this IBC was to protect, to establish IBBA, Insolvency Bankruptcy Board of India, which is a regulator, which is similar to SEBI or other RBI or IRDA, etc. And the most important objective of this code, which is actually had resulted in a knee-jerk reaction also, is that alteration of the order in the priority of the payment of the government dues. So now we know that whenever a company is facing that kind of actions under SURFACI, the government dues is to be paid on priority without even settling the other creditors or financial creditors. But under the IBC, that priority has been taken down to the fourth point in the row, because they will be settled only after settling the financial creditors or operation or equivalent of operational creditors, employees and workmen. So that is also one of the major change that is brought in by this legislation, altering the priority of the government dues. So, as I had briefed earlier also stating that now there is only a single law which is actually consolidating everything under the one umbrella instead of having a Companies Act 2013 to govern the creditors' debts, and SICA is got repealed, and Presidency Township Act and Provincial Act 2000, though it is not repealed now, it is still it is not into action, and only IBC is now governing all these credit-related relationships. And the major other factor which is to be considered under the new law regime is the time-boundedness of this particular law. The insolvency and bankruptcy earlier took, as I had mentioned earlier, it took years to complete. The ease of doing business in India was 136 at the time when this law was introduced, and the average time to dissolve a company was 4.5 years, and there are many companies which actually have gone up to even 35 years to liquidate, or is still continuing on the books even without finding a solution to that. After IBC, India's rank jumped to around 63, which may further increase, and maximization of the value of the assets of such persons, and there is a timelines mentioned. 180 days is the time period for this resolution period. Now there is a little bit relaxation on it, which is actually it can be go up to 270 days with the permission, and in some cases it can go up to 330 days. But anyway, 330 days is less than 1 year, which is actually more better than any other previous this kind of laws. And what are the applicability of this code? To whom a particular legislation is applicable is important to understand. This is applicable for companies and limited liability partnerships. And these are applicable for companies under Special Act of Parliament, and another important coverage is on the partnerships and individuals. So it is covering the entire community, which includes corporations as well as individuals, partnerships as well as LLPs, and other special companies which are formed under Special Act of Parliaments. So if you take a bird's eye view of this particular legislation includes insolvency, bankruptcy, liquidation, and one more thing is called voluntary liquidation. Voluntary liquidation aspect I am not taking in this topic today. I will take it on another day separately. And if you see this legislation, there are multiple regulators. Regulations is not only the governmental side. One regulator is called Insolvency and Bankruptcy Board of India, who is the major regulator for this. And apart from that, there are insolvency professional agencies like ICSI IIP, ICA IIP, ICMA IIP, who are actually regulating the insolvency professionals code of conduct. And the third regulator, you can call them as insolvency resolution professionals, who themselves actually are playing a pivotal role in the entire IBC or CIRP or liquidation activities. And along with this regulator, there is a judicial forum. There is a specific dedicated judicial forum to resolve any disputes or matters which are connected with the insolvency resolution. Those are called adjudicating authorities. We know that there are national company law tribunals or national company law appellate tribunals to resolve any matters connected with the corporates, and civil courts does not have jurisdiction on the matters which are coming under this NCLT and NCLAT. Under the IBC, NCLT has been given the additional power to act as an adjudicating authority for the IBC matters. So now the NCLTs are acting as adjudicating authority, and NCLAT is acting as the appellate authority for any matters which is connected with the insolvency and bankruptcy for the corporate persons. And for the individuals, the authority is debt recovery tribunals and debt recovery appellate tribunals. For the after adjudicating authority, if you are aggrieved, you can go to appellate authority, and then the final authority will be the Honorable Supreme Court of India, who is adjudicating on the matters to attain its finality. So, if you see the act itself or the code itself, it is divided into actually basically 4 parts. And part 2 of the code is actually dealing with the companies and limited liability partnerships and their insolvency. And part 3 is now partially notified, deals with the individuals, partnerships, and personal guarantors of the corporates. And who can initiate an insolvency resolution? So insolvency, suppose a company, as I had mentioned earlier, insolvency is a stage in which a company or a corporate person is unable to pay its bills or dues as and when it becomes due and payable. That means the company is unable to pay its dues. So when a company is facing that kind of situation, what is to do next? And what are the next steps we need to take? So one is that an application can be filed before the adjudicating authority, that is National Company Law Tribunal, by three persons under three different sections. One is that a financial creditor can file an application. Second is an operational creditor can file an application. Third is the corporate debtor itself can file an application if the particular company or an LLP commits a default in the payment of its dues. We will see these terminology like corporate debtor, financial creditor, operational creditor, etc. in coming videos. So what is the trigger point? Trigger point is that there is a debt and debt has got defaulted. What is a default? Default means a non-payment of a debt by a corporate when all or part of its due and payable is not paid by the corporate debtor. And what is a debt? Debt is a liability or an obligation in respect of a claim of a person, includes financial debt and operational debt. So this is for today, and thank you very much for the patient listening. I will be continuing with the rest of the insolvency code in my next videos. Thank you.